So again,
it's kind of hard to avoid the word content. And it's kind of hard to avoid the word viewpoint here, isn't it?
I don't dispute that it's related to content, but I don't think it reflects Congress seeking to set out in advance what kind of speech we should have reflecting certain views on certain topics. Instead, it's about trying to close off a vulnerability that our foreign adversary nation could exploit. And I would be remiss if I didn't point out that even if you thought this was content-based, all that means is that we're in strict scrutiny. And as the DC Circuit recognized here, we think that this law serves compelling national security concerns that sound in some of the same arguments I'm making here, and that have a long-standing correspondence to history and tradition of trying to prevent foreign control.
And then we get to the question whether there's a less restrictive means. I get that, and whether disclosure might suffice. On the data security point, your friends on the other side make the argument that if that were the concern, Congress could ban TikTok US from sharing data with anyone, and on pains of penalties that would put people in prison and shut the company down in the future, as the government did, for example, with Arthur Andersen. Why isn't that a less restrictive means available?
So I was surprised to hear Petitioner offer that up today, because there was a long course of discussion between the executive branch and ByteDance and TikTok leading up to Congress's enactment of this act that spanned over 4 years, an extensive conversation about what limitations could be placed to protect Americans' data. And it was never a suggestion that there would be any way to create a true firewall that would prevent the U.S. subsidiary from sharing data with the corporate parent. And the reason for that sounds in the technological features of this application. I think there can be no reasonable dispute that the source code development and the maintenance of this algorithm rests in China, which is why China has sought to try to control export restrictions with respect to the algorithm. And what that means is you need substantial data flows between the companies in order to continue to modify that algorithm, refine it, and so forth. So I don't think that that was an option ever on the table, including with respect to the proposed national security agreement that was insufficient in protecting our data privacy and security concerns.
That didn't come across enough in the briefs. If we are in the world of data protection as opposed to content control, I think it's hard to get around the post-divestiture provision that says you can't do business with them on the algorithm, because that very much is content-based. It's a content-based restriction. But what you're saying is you can't do it for a data control reason, meaning that you can't really run their algorithm without sharing the very data that we are concerned about as a threat, correct?
That's right, Justice Sotomayor. And you don't have to take my word for it. You can look at the specific terms of the National Security Agreement that ByteDance itself proposed. The relevant definition of the accepted data is at JA 239 to 240, and it references categories of information that would, of necessity, technological necessity and business necessity, have to flow back to China. And the relevant categories are in the sealed appendix, but I would really encourage the court to look this up because it's eye-opening. It is at the Court of Appeals sealed appendix 249 to 252 and 254. If you look at that information, it was a wealth of data about Americans that was going to have to go back to China in order for the platform to just continue its basic operations. And there's a legitimate commercial justification for that, but it creates this gaping vulnerability in the system because once that data is in China, the PRC can demand that ByteDance turn it over and keep that assistance secret. And the one final point on this is that ByteDance was not a trusted partner here. It wasn't a company that the United States could simply expect to comply with any requirements in good faith. And there was actual factual evidence to show that even during a period of time when the company was representing that it had walled off the US data and it was protected, there was a well-publicized incident where ByteDance in China surveilled US journalists using their location data. This is the protected US data in order to try to figure out who was leaking information from the company to those journalists.
General, you want us to look at that and you get to look at it, but your friends on the other side don't get to look at it. That doesn't seem fair.
That's the sealed appendix, Mr. Chief Justice, so it's their information. They can look at it. It's just under seal to protect their proprietary business information.
General, so I want to go back to the discussion about content discrimination, and we're going to shut Joe up. Here, it seems to me like we are saying to ByteDance, we want to shut you up. And so let's say that I think that that is content discrimination based on speaker. Tell me if I think that, tell me if I have to conclude that it is also speaker-based discrimination and content-based discrimination for TikTok.
No, it is not. And the reason for that is because it would be an anomalous principle to say that an entity outside the United States that can't assert its own First Amendment rights can somehow manufacture that right through the expediency of forming a U.S. subsidiary, especially one that it wholly controls.
So you don't have to stand on that argument that you were having with Justice Alito and Justice Gorsuch to still have your point about content discrimination.
That's right. And I think if you're focusing in on the relevant U.S. entities here, TikTok US and the users themselves, this act isn't regulating them in any way. It's not trying to dictate the algorithm that TikTok US can use. And in fact, community on the site.
Well,
One
I don't
last
know,
quick
Jeff.
question. Sorry, just
No,
one
no,
last
go
quick
ahead, go
question. Justice Gorsuch had asked your friends on the other side whether the new administration on January 20th could extend the deadline. What's your position on that?
So I think it tees up a statutory interpretation question of whether there can be an extension after the time period for divestiture has lapsed. I would think the court might start with its decision in the Hawley Frontier case, which did recognize the ability to get an extension after a lapse like that.
So it's your position that they could?
We have not run it to ground in part because it's simply not presented here, and I'm not prepared to take a position on that statutory interpretation question. I do want to emphasize, though, that my friends have pointed to January 19th or 9 days from now as a moment when TikTok might go dark. At the outset, of course, Congress was hoping to prompt a divestiture, but I think the more important thing to focus on now is that even if that were to happen, Congress specifically anticipated it and provided authority to lift these restrictions as soon as there's a qualified divestiture. And the reason for that is because foreign adversaries do not willingly give up their control over this mass communications channel in the United States. And I think Congress expected we might see something like a game of chicken, ByteDance saying, we can't do it, China will never let us do it. But when push comes to shove and these restrictions take effect, I think it will fundamentally change the landscape with respect to what ByteDance is willing to consider. And it might be just the jolt that Congress expected the company would need to actually move forward with the divestiture process. So
Well,
it's not irrevocable.
That's an interesting point, and I hope Mr. Francisco or Mr. Fisher, whoever's delivering the rebuttal, will address it. So if we were to affirm and TikTok were forced to cease operations on January 19th, you say that there could be divestiture after that point and TikTok could again begin to operate the way, continue to operate.
That's exactly right. There's nothing permanent or irrevocable that happens on January 19th. And I think that Congress might have thought that we get in a situation here where a foreign adversary is doing whatever it can to just not comply. It's hoping the United States is going to blink first through our court system or through the executive branch getting cold feet about enforcing the law. But Congress set a deadline, and I think it thought that deadline would have a forcing function.
Well, let me ask you a question about your effort to draw a distinction between ByteDance's speech and TikTok's speech. So suppose that the People's Republic of China funds a movie and there is an entity in the United States, a U.S. corporation that thinks, wow, this is a great movie. And while the PRC would not have a First Amendment right to show it in the United States, would you say that the American company would not have a First Amendment right to do that because whatever expression there is in that movie, it's the PRC's expression, it's not their expression?
No, I wouldn't make that argument. And I want to be really careful.
I thought that was the argument that was being made, no?
No. So our argument is that this is not a direct regulation of protected speech in the first place, or at most it would warrant intermediate scrutiny because of the indirect effects that it might have on the American users or on the U.S. subsidiary. We're not suggesting that if Congress sought to directly regulate and prohibit speech in the United States based on concerns about its content or viewpoint, that's somehow immune from First Amendment scrutiny just because it comes from a foreign source. Obviously, that kind of law is going to trigger strict scrutiny. And I imagine it would be a different constitutional analysis because it's hard to imagine the same profound national security harms that would exist in that scenario as compared to what we have here.
Thank you.
General, isn't the whole point of the divestiture requirement that the content on TikTok would be different if it was owned by a different company? I'm still struggling with your insistence that this is content neutral versus content based when we have that kind of circumstance?
The reason that I am continuing to try to hold the line on that is because there is nothing in the act that would directly dictate any different mix of content on TikTok. The U.S. subsidiary could use the same algorithm, show the same content by the same users in exactly the same order. It's not about trying to interfere with the U.S. subsidiary's exercise of editorial judgment in any relevant sense. Instead, all Congress was doing was homing in on the problems of having a foreign adversary be able to interject itself and be able to harvest
But
the
your
data.
friends on the
or
other side
exercise-
say that the motivation for doing that is because the foreign adversary might influence or change the content. So content content matters, doesn't it?
I think that content was relevant to Congress's concern about an adversary having control over the communications channel. I think not, again, because of any particular concern about viewpoints or subjects, but just
isn't
that
that
this would be
isn't that relevance enough to trigger at least some scrutiny, with a heightened scrutiny from the standpoint of our legal tests?
I certainly understand that intuition, and if the court thought that it were prudent to simply try to rule narrowly here and not dictate broader First Amendment principles, we have no problem with the court assuming that heightened scrutiny applies. We think the law easily satisfies it. We do think that intermediate scrutiny is a more appropriate framework for this kind of law that's not directly targeting protected speech. But in any event, there's a compelling national security interest here, and the law isn't just narrowly tailored, it's precisely tailored. It's trying to fix the thing that's creating the problem, which is the PRC's involvement and the Chinese government's ability to exercise this control over the corporate entities.
How are we supposed to think about the two different rationales here and how they interact? The data collection rationale, which seems to me at least very strong, the covert content manipulation rationale, as the hypotheticals have illustrated, raise much more challenging questions for you about how far that goes. And if that alone, if you didn't have the data collection piece, you only had the covert content manipulation piece. And then Mr. Fisher's point, Mr. Francisco's, that Congress would not have enacted this just based on the data collection rationale alone. Just your understanding of how the two arguments fit together.
Sure. And let me walk through our defense of the data protection rationale and why we think it's a full justification for this law, and the court could stop there and then be responsive to their arguments that somehow the interest in preventing covert manipulation somehow taints it. So just on data protection, I think that it should be beyond dispute that, of course, our nation has an enormous interest in keeping the sensitive data out of the hands of our foreign adversary. And it should also be beyond dispute that our foreign adversary has an existing capability through its laws and through the way that these companies are integrated to get its hands on that data. There is no question that Congress was sincerely motivated by that concern. There's a whole lead up to the statute here where the executive branch across two different presidential administrations was expressing concerns about the data problems. Congress was extensively briefed on those problems. It passed a companion data protection statute at the same time that was intended to prevent selling data to foreign adversary nations. The statute is shot through with protections that I think are key to this concern about closing off the vulnerability of access to the data. So that's a sincere justification for Congress's desire here to act. We think it's a compelling interest and it's narrowly tailored. Then you get to the question of what to do about the fact that there's also this interest in covert content manipulation. And in the First Amendment context, this court in cases like Heffron has made clear that once you have a justification that satisfies the First Amendment, you don't need to go further and look at other justifications to decide whether they would independently satisfy First Amendment scrutiny. So I think it's not necessary for the court to go on and probe whether it thinks that covert content manipulation itself independently justifies the law. Now, my friends say that's all fine and good, but they think covert content manipulation is just per se illegitimate. And I honestly don't understand how that argument could carry the day, because just imagine if Congress passed a law that said the PRC can't covertly manipulate TikTok. Obviously, that law is not going to violate any constitutional principle. It's a laudable goal, I think, for our legislature to protect us from foreign adversary interference like that. And so there's nothing that's inherently impermissible about wanting to guard against that risk. Maybe you could say that it sweeps in too much protected speech in the way it's operationalized in the act here, but there's certainly no fundamental taint or anything akin to racial discrimination to call into question whether Congress could seek to vindicate that as one of many interests. So I guess to just kind of bring it all together, what I would say to the court is they have basically acknowledged that data protection is a compelling interest. That was Congress's real interest. It provides a sufficient basis on its own to uphold this law. The court could say just that and affirm.
I don't know how we do that unless we accept your argument that the post-divestiture provision that stops them from conferring on the algorithm is not a speech impediment, meaning it's very hard for me to say that it's not motivate to decide that question, that it is a speech impediment, and one that on its face itself has to be analyzed separately from the data.
So, Justice Sotomayor, let me begin by saying, again, that we do think that an interest in preventing any operational agreement between the U.S. subsidiary and ByteDance, which is the relevant provision you're talking about, is justified by data protection alone. And that includes with respect to cooperation on a content recommendation algorithm, specifically because of the concern that it necessitates data flows between the companies. So I think that as a factual matter, that could justify Congress enacting. But to the extent that you think that actually the prohibition on coordinating with respect to an algorithm reflects some kind of impermissible content-based problem with the statute has a severability clause, and I certainly don't think that it would give the court a basis to invalidate this law or to stop it from operating with respect to all of the provisions that operate to protect data security. At most, it would suggest that that little piece of the law has to be on its own severed from the rest of how the statute operates.
How does that affect whether we would apply, because assuming it's data protection, then I would think that strict scrutiny wouldn't necessarily apply. I could understand applying intermediate scrutiny. But how do we do that with respect to this part, the algorithm issue? How do we get to intermediate scrutiny with respect to that?
The way you get to intermediate scrutiny there is to recognize that prohibiting foreign adversary control over the operations of the platform, including with respect to the fundamental backbone of the system, is not based on any protected speech or content based in the relevant sense. I've been thinking of it as akin to something like a piece of software you might have on your phone that would allow the Chinese government to listen in on every American conversation. If Congress wanted to enact a law that patched up that vulnerability and said, you can't use that piece of software or you can't coordinate with Chinese companies with respect to it, clearly we would recognize that closing off that capability of China is a laudable and, in fact, compelling government interest. And I think when it comes to the risks that foreign adversary control pose here, it's similar in kind. It's simply trying to prevent access by the Chinese government to the TikTok system writ large, and that includes through the use of the algorithm.
Thank you.
Could the president say that we're not going to enforce this law?
I think as a general matter, of course, the president has enforcement discretion.
And would that then adequately protect, would that be binding? In other words, protect the regulated community so they could rely on that under due process principles going forward?
That raises a tricky question. So I think there would be
then
a
it's not
strong.
going to be adequate. Right?
Well, I think there is a strong due process argument that the third-party service providers could invoke if there were enforcement action based on a period of time when the president said the law wouldn't be enforced. The kind of
They're not going
canonical
to take
case.
that risk unless they have the assurance that a presidential statement of non-enforcement is, in fact, something that can be fully relied on because the risk is too severe otherwise, right?
I think that they might judge that based on this court's precedent in the due process space and principles of entrapment by estoppel, maybe they have a sufficient safeguard here to allow them to continue to operate. I would think even before a non-enforcement policy were announced, of course, the president-elect would want to review all of the updated national security information that has come in over the last 4 years that undergird Congress's judgment here. But the final thing I would say is that even if you think the third-party providers are simply going to choose not to continue to provide these services because it's too much of a risk to take on, again, that's not anything permanent or irrevocable, and that might be just what the PRC and ByteDance need to start taking seriously some of the public reporting about interest in acquiring the company.
At one point, Mr. Francisco suggested that what we might want to do and what he would regard as certainly preferable to a decision affirming on the merits is to issue an injunction pending, I guess, consideration of what we now regard as the cert petition that was filed here. What do you think of that suggestion?
So I think this court doesn't have any basis to enter a temporary injunction unless it thinks petitioners are likely to succeed on the merits of the First Amendment claim. And to be honest, I think that there is no argument to be made that you should find that likely success. This is an act of Congress. This isn't some unilateral action by the executive branch, but it actually was action in parallel between the executive and Congress, where Congress took action to close up a loophole in some of our laws. The executive had tried to force divestiture of TikTok under the Trump administration, but that had gotten tied up in litigation about those authorities. So Congress came in and provided additional authority based on a substantial record, including with respect to the data harm. And I don't see any basis for this court to displace the deadline that Congress set without finding that actually there is a potential First Amendment problem here.
Do you think we have the authority to issue an administrative stay as we have done in other cases, or do you think that the January 20 deadline prohibits us from doing that?
I don't think this court has a formal basis to not issue an administrative stay if it believed that that was necessary to assist in the court's own consideration of the case. And I would obviously defer to the court in whether it has a sufficient time to resolve the case, but we are here ready to submit the case today. And I think it is in the interest of Congress's work and our national security to resolve the case and allow the statute to take effect.
Can I just test to see whether your recollection of what Mr. Francisco said about a warning is consistent with mine? I did not hear him say, he can address this in rebuttal, that it would be acceptable to his client if Congress had said there has to be a stark warning on every TikTok, such as, warning, the communist China is using TikTok to manipulate your thinking and to gather potential blackmail material. Did you hear him say that that would be okay?
I don't think he's made that concession, but even if he had, I don't think that would address the government's national security concerns. And one of the points here is that it's not just data privacy. So even if you could somehow put users on notice that the PRC could obtain their data and they choose to disregard that, it's not a data privacy interest, it's a national security interest. There's a distinct sovereign harm to the United States if our foreign adversary can collect this massive data set about 170 million Americans. And as Justice Kavanaugh touched on, there are a lot of teenagers using TikTok today who might ignore a warning like that and not really care, but they're going to grow up and they might become members of our military. They might become senior government officials. And for the Chinese government to have this vast trove of incredibly sensitive data about them, I think obviously exposes our nation as a whole to a risk of espionage and blackmail.
Thank you.
I did want to touch briefly on the questions about history and tradition here, because my friends have said several times that the Communications Act of 1934, which we think is roughly analogous to the type of restriction that Congress was seeking to enact here, is justified entirely by concerns about scarcity, how you can't have sufficient bandwidth. And I, of course, recognize that scarcity is what created the need for a licensing regime in the first place. But I think it's important to clarify the historical record here that in choosing to limit foreign control of radio stations, of broadcast stations, Congress specifically cited a concern about national security. That is written into the statute. National defense was one of the listed purposes of having that kind of restriction. And so I don't think my friends can succeed in being dismissive of that concern about history and tradition and what it shows about the national security judgments that undergird this law. The one other factual point I wanted to make, to be responsive to a few points that my friends have touched on, relates to whether TikTok US has the ability to alter this algorithm, whether divestiture is feasible, how ByteDance has manipulated the platform in the past. With respect to the algorithm, I think we're simply talking past each other. We don't dispute that TikTok US might engage in some functions in the United States to customize the algorithm for a US audience. The thing we're worried about is happening long before that, over in China, where ByteDance is developing the source code, creating the basic backbone and functioning of the system, and is then blasting out the algorithm for use by the various subsidiaries in their home country. So we're not seeking to regulate any activity that TikTok US is engaged in here. Instead, what Congress is doing is trying to close off the vulnerability of PRC access abroad. With respect to the feasibility of divestiture, my friends have said it would have been impossible to do this within 270 days. At the outset, obviously, there's no inherent impediment to divesting a social media company. We just saw Elon Musk buy X or Twitter in about 6 months from offer to completion. And even with respect to this particular company, I think my friends are not well positioned to complain about the timeline because they've been on notice since 2020 that unless they could satisfy the federal government's national security concerns, divestiture might be required. But in any event, I don't think that the court should fault Congress for trying to balance competing interests here in making sure that there was a period for compliance and trying to preserve access to the platform for Americans while taking steps to safeguard against the risk to national security. Finally, with respect to the question of whether ByteDance has taken action on the PRC's demands, there is evidence in the record that Congress consulted to demonstrate that outside of China, ByteDance has taken action to misappropriate data at the PRC's request. That included efforts to track dissidents in Hong Kong, protesters there, to track Uyghurs in China itself. We know that ByteDance has misappropriated U.S. data with respect to surveilling of U.S. journalists, and there was evidence in the record reinforcing the conclusion that ByteDance has been asked by the PRC to undertake efforts to censor content and manipulate the platform at the behest of the Chinese government. So I don't think there is a factual basis to dispute the record that Congress had before it. If the court has no further questions.
General, if I understood correctly, under President-elect's first term, he passed an executive order requiring divestiture, correct?
That's right.
And this, that was challenged in court and state as a result of him exceeding his executive power to do that. But this bill followed a bipartisan investigation, correct?
Yes, that's right.
I am a little concerned that a suggestion that a president-elect or anyone else should not enforce the law when a law is in effect and has prohibited a certain action, that a company would choose to ignore enforcement on any assurance other than the change in that law. But putting that aside, on the 19th, if it doesn't shut down, there is a violation of law, correct?
Yes.
And whatever the new president does doesn't change that reality for these companies.
That's right.
How long is the statute of limitations in effect, assuming that they violated it that day and later continue to violate it? But how long does the statute of limitations exist for a civil violation of this sort?
It would be a 5-year statute of limitations.
Thank you.
Thank you, counsel. A rebuttal?
Thank you, Mr. Chief Justice, for points, all of which go to why we think this law would fail, whether you applied intermediate scrutiny or strict scrutiny. I'd like to begin with the least restrictive alternative, simply prohibiting TikTok Incorporated from disseminating any of the sensitive user data to anyone, including ByteDance, under the threat of massive penalties. That is definitely a less restrictive alternative. Now, my friend pointed to the NSA negotiations. Well, the sensitive user data that we're talking about and that were of concern in the NSA negotiations were not the type of technical data that she's talking about. The NSA did allow certain types of non-sensitive technical data to go back and forth, but that wasn't anybody's concern. And as we say in page 23 of our briefs, they simply cut off the negotiations without ever raising those concerns. But to be clear, if that's a concern, sweep that into the ban too. Put in that non-sensitive technical data into the ban too. We'll deal with that. It's a lot better than simply being forced to shut down. So that is most definitely a less restrictive alternative that would address data security. We talked about the under-inclusiveness and Temu and Shein, the two large e-commerce sites. Justice Kagan, you might have seen Temu during the Super Bowl. It was heavily advertised. It's one of the most popular e-commerce applications in the United States. It's got 70 million users. Justice Sotomayor, you were asking what they collect. This is from Joint Appendix 339 to 343, the U.S.-China Economic and Security Commission Review Report. Shein relies on tracking and analyzing user data, draws on customer data and search history with the assistance of artificial intelligence algorithms. It requests users share their data and activity from other apps, including social media. So they apparently go into your social media apps and suck up all of the information. Because they're e-commerce apps, they take names, addresses, and credit card information. If you look at the privacy policies on their website, they collect location data. It looks like they might even collect, at some level, GPS location data. So they collect massive amounts of data. Point 3, their mere covertness argument makes no sense for the reasons that the court explored. If mere covertness were the issue, a disclosure would make perfect sense. Yet they're not concerned about mere covertness. They're concerned, as my friend suggested, with getting Americans to argue with each other. Well, you know, as far as I can tell, that's what news organizations do in this country every single day. That's what we call editorial content. That's what we call content itself. And so it's trained directly on the content. But even if you thought somehow that the mere covertness were the issue, that definitely could be addressed through a risk disclosure. So the data sharing ban, the risk disclosure, those are obvious, less restrictive alternatives. And had the government considered them and rejected them, we would be in a different position. But if you look at this record, those are two less restrictive alternatives that the government did not address at all. Whether you apply strict scrutiny or intermediate scrutiny, that is fatal, because under both standards, restricting speech has to be the last resort, not the first one. And when you fail to consider less restrictive alternatives, you fail under either standard. My final substantive point is we absolutely think this court has the authority to enter an administrative stay. I didn't understand my friend to disagree with that. We think that given the enormity of this decision, given the complexity of this case, it would make perfect sense for this court to enter an administrative stay. I also think you could enter a preliminary injunction. Yes, likelihood of success is one standard, but you don't have to determine ultimate success. And as you do in other related contexts, like with respect to stays, you often make clear that you are not addressing the merits of the case. I think you could do that here. The bottom line, Your Honor, is this case ultimately boils down to speech. What we're talking about is ideas. And my friends on the other side, when you cut through everything else, are ultimately worried that the ideas that appear on the TikTok platform could in the future somehow manipulate Americans, could somehow persuade them, could somehow get them to think something that they ought not be thinking. Well, that whole notion is at war with the First Amendment. If the First Amendment means anything, it means that the government cannot restrict speech in order to protect us from speech. That's precisely what this law does from beginning to end, whether you look at its text, whether you look at the government's justifications in its brief, where they talk about being worried about speech criticizing our leaders or undermining democracy. It's what you see in the House report, which drains specifically on the dangers of misinformation, disinformation, and propaganda. And it's what you see in this legislative record writ large, which is saturated with objections to TikTok's existing content. We ask that you reverse the court below. Thank you.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.
Seated.
We will hear argument this morning in case 24-656, TikTok versus Garland, and the consolidated case. Mr. Francisco.
Mr. Chief Justice, and may it please the court. Under the Act, one of America's most popular speech platforms will shut down in 9 days. That shouldn't happen for 3 reasons. First, TikTok Incorporated is a U.S. company speaking in the United States. The Act requires it to go dark unless ByteDance executes a qualified divestiture. Whether you call that a ban or a divestiture, one thing is clear. It's a burden on TikTok speech. So the First Amendment applies. Second, the Act is content-based from beginning to end. It applies only to social media platforms that have user-generated content except for business, product, and travel reviews. Within that content-based universe, it singles out a single speaker for uniquely harsh treatment. And it does so because the government fears that China could, in the future, indirectly pressure TikTok to disseminate foreign misinformation and propaganda. Finally, the Act can't satisfy any standard of scrutiny. I understand it, we go dark. Essentially, the platform shuts down.
Unless there's a divestiture.
Unless there's a divestiture, unless President Trump exercises his authority to extend it by night, but he can't do that on January 19th. On January 19th, we still have President Biden. And on January 19th, as I understand it, we shut down. It is possible that come January 20th, 21st, 22nd, we might be in a different world. Again, that's one of the reasons why I think it makes perfect sense to issue a preliminary injunction here and simply buy everybody a little breathing space. This is an enormously—
What do you mean by shut down too? Can you just spell that out?
So
if you
the app is not available in the app stores. That's at a minimum. But in addition, what the Act says is that all of the other types of service providers can't provide service either. Now, there's enormous consequences for violating that for the service providers. So essentially, what they're going to say is that, I think we're not going to be providing the services necessary to have you see it. So it's essentially going to stop operating. I think that's the consequence of this law, which again is why a short reprieve here would make all the sense in the world. It's an enormously consequential decision, and I think all would benefit if it weren't necessary.
Thank you.
Justice Barrett.
So I just want to, just kind of following up on Justice Kavanaugh's questions. Let's say I agree with you that some level of scrutiny applies, and I'm trying to figure out which level of scrutiny applies, and I'm trying to figure out if there's content discrimination. And let me ask you a different question than I did before about the algorithm. I mean, you keep saying shut down. The law doesn't say TikTok has to shut down. It says ByteDance has to divest. If ByteDance divested TikTok, we wouldn't be here, right? If ByteDance was willing to let you go and willing to let you take the source code with you, that would be fine, right? We would not be here.
Well, Your Honor, if ByteDance divested, then the law wouldn't fall on TikTok. But the law will, not ByteDance.
But that's because of ByteDance's choice, right? I mean, this is like Justice Kagan's point. I mean, I'm trying to figure out how we account for, and the choices of third parties, that the whole reason for the law being passed in the first place.
Yeah, Your Honor, I still don't, I think that the way the analysis works is step one, is there a First Amendment violation?
Right.
Step two, you get to the question that we're grappling with. What standard of scrutiny do you apply? Typically, what you do is you ask, is this law content-based? Is it content-based based on its face? Is it content-based in its decision? Here, we know it's content-based on its face because it says what it says. We know it's content-based in its motivation because the government concedes it's content-based in its motivation.
Well, that's not quite what I'm asking. I mean, let's see, that's the dispute between you and the government. Is it content-based if it's about divestiture and not about telling TikTok what content it can display on the platform?
And I think it has to be, because I think that really goes to the first question. Does the burden fall on the speaker? If the burden falls on the speaker, that triggers the speaker's First Amendment rights. But the law is in fact content-based, whether it comes in the form of a divestiture or something else. when the law specifically says it's content-based, we're worried about the content on the platform. And when the government tells you that one of our reasons, one of the things that we're worried about is TikTok, not ByteDance, but TikTok Incorporated and TikTok in the United States will, absent the divestiture, have a mix of content that we find objectionable. They will mix around their videos in a way that is too pro-Chinese or too anti-American.
Okay,
and that is TikTok, the platform.
Let me just ask you one last question. Why is it impossible to divest in the 270 days, even assuming that the Chinese government hadn't said you couldn't?
Sure, and this is the exchange I was having with Justice Gorsuch. There are two basic reasons. The first is that the underlying source code, that's the source code that comes in here and then has to be converted.
But that's what Justice Gorsuch said, just not ever. So it's not really that you can't do it within the time frame. It's that you really couldn't ever divest because you never are going to get the source.
So, well, let me unpack that a little bit. No, it's that with the underlying source code, it takes a team of engineers to update and maintain that. It would take us many years to reconstruct a brand new team of engineers to do that with respect to the source code. With respect to the sharing of content, that was the different reason. In theory, we could kind of send our salesmen around the world, go to Ireland, go to Finland, go to every country and say, look, you used to automatically get our content, but now you got to separately sign up for our platform.
Last point, let me make sure I understand what you're saying. It's not that you couldn't execute the disentanglement. You could say we're independent. You just can't recreate TikTok in any kind of way.
Well, I think that any new TikTok would be a fundamentally different platform with different content, which is yet another reason why I think this is a content-based restriction that falls directly on TikTok Incorporated itself in our platform.
Justice Jackson?
So I guess I'm back to some of the questions that Justice Barrett and Justice Kagan asked about the sort of threshold issue that you point out, which is there a burden on the speaker? I'm trying to understand what the burden is that you are articulating and whether it really isn't about association and not speech. You say you have in your brief some cases that talk about American speakers being free to choose whether to affiliate with foreign organizations. And the colloquy you had with Justice Kagan made me think that what you're really complaining about is the inability to associate with ByteDance and its algorithm. That it's not really about, if TikTok came up with its own algorithm or bought an algorithm from some other company or devised it or whatever, this law would have nothing to do with them from your perspective. But the problem I think you're articulating, and this is, I'm seeking your clarification.
Sure.
The problem I think you're articulating is that you want to use ByteDance's algorithm and therefore associate with ByteDance, and Congress has prohibited that by requiring divestiture. So isn't this really a right of association case under the First Amendment?
I think it's both, Your Honor. I do think that that is a component of it. We want to use the algorithm that we think reflects the best mix of content. That's the algorithm that reflects the best mix of content. What this law says is we can't do that unless ByteDance exercises a qualified divestiture. But I also think more directly what this law does is it says that TikTok Incorporated, if ByteDance doesn't exercise a qualified divestiture, you have to go mute. You cannot speak at all.
No, I don't think it says that, though. I mean, if TikTok were to post-divestiture or whatever, pre-divestiture, come up with its own algorithm, right? Then when the divestiture happened, it could still operate. It doesn't say TikTok, you can't speak.
I think that's theoretically correct, Your Honor, but I think that also underscores the content-based nature of the restriction.
No, but the fact that that's true suggests that you're wrong about the statute being read as saying TikTok, you have to go mute. Because TikTok can continue to operate on its own algorithm, on its own terms, as long as it's not associated with ByteDance. So isn't this really just all about association?
Your Honor, I think it is partly about association, but I'm going to take another shot at explaining why it's not just about association.
Okay, well, let me just take you down the association path for a second, because if it is about the association of TikTok with ByteDance, then don't we have cases that seem to undermine your view that Congress can't do this? I mean, I thought we had cases about Congress prohibiting association with terrorist organizations, prohibiting association with foreign adversaries. And so why doesn't this fall into that kind of group of our jurisprudence?
Well, at least as I understand all of those cases, they applied strict scrutiny. The material support statute most definitely applied.
And
strict
ultimately
scrutiny.
upheld the law, so fine.
But sure, and I think if we go down the strict scrutiny road here, I don't see that this law can possibly be satisfied under the interests that they assert here. But I do want to emphasize why this is also about TikTok speech. Even under your hypothetical, where theoretically they can say something differently than they are saying today, that in and of itself is a direct restriction on TikTok speech. They can't engage in the speech they want to engage in. They have to engage in a different kind of speech, the speech they don't want to engage in. That is a direct burden on TikTok incorporated speech.
All right, I think I understand that argument. Let me ask you a question about your colloquy with Justice Kavanaugh. Did I understand you to concede that there is a compelling interest and that the problem is really tailoring? I mean, you said, I understand the risks. I don't hear you suggesting that the risks don't exist. So it sounds like we've gotten past, even if we're in strict scrutiny world, we've gotten past the compelling interest part of this.
No, Your Honor. What I was saying is that all you had standing alone were the data security. That would be a different case. Here, when you have the content manipulation sitting right alongside of the data security, that taints the data security rationale. If Congress came in and said, we're passing this law for two reasons. One, we really care about data security. And two, we hate the speech on TikTok. The data security wouldn't alone sustain that law under cases like Mount Pleasant.
I understand, but why you're equating, we don't want foreign adversaries to be able to manipulate the content on this platform. You're equating that with we hate the content. And I'm just trying to understand why.
Because content manipulation is by definition a content-based distinction. Look, everybody manipulates content. There are lots of people who think CNN, Fox News, the Wall Street Journal, the New York Times are manipulating their content. That is core protected speech. That's why they put so much weight on this mere covertness.
Right, but that analysis is just about content-based versus content neutral, and therefore whether you apply strict scrutiny. I'm in the strict scrutiny world, okay? I'm assuming that you're right, that strict scrutiny applies, and now prong number one in that world is, does the government have a compelling interest? And so I'm trying to understand why the government's argument that we have data manipulation concerns, which I understood you in colloquy with Justice Kavanaugh to say is a risk, and we are concerned based on what Justice Gorsuch says when he's looking at the facts, that the government contends that there's this real problem with this foreign adversary doing manipulation in other places. Are you saying those are not compelling government interests?
I am 100% saying that content manipulation is not just not a compelling governmental interest, it is an impermissible governmental interest. You could not go to CNN or Fox News and say, we're going to regulate you because you're manipulating the content in the way that we don't like. That is per se impermissible.
Okay, can I just ask you one last thing? You say with respect to the tailoring issue, that disclosure, you think, is a possible, more narrowly tailored way of handling some of this. And I guess I'm just wondering whether disclosure under this court's case law and the law of other lower courts doesn't carry its own First Amendment complications. That wouldn't we have compelled speech problems if disclosure was required in this situation?
Sure, Your Honor. Now, look, I might think so because I think that the factual predicate is wrong, but they think the factual predicate is right. And if the factual predicate is right, then there are no First Amendment problems at all under Zouder and the cases that you're suggesting. And that underscores the larger problem here. Not all disclosures are perfect. I'm not here to argue that they are. But you've always got to consider what the alternative is. And here the alternative is shutting down one of the largest speech platforms in America. The reason there's no evidence in this record as to disclosures is because Congress never even undertook that balancing in the first place.
Thank you.
The bare minimum that has to be done before we take an unprecedented step of shutting down the voices of 170 million Americans.
Thank you.
Thank you, counsel. Mr. Fisher?
Mr. Chief Justice, and may it please the court, wholly apart from the company's legal interests here, the Act directly restricts the rights, the First Amendment rights of American creators to participate and speak in what the court a little less than a decade ago called the modern public square. And what you might say today is the most vibrant speech forum in the United States of America. And the Act, therefore, is inescapably subject to strict scrutiny because of the First Amendment implications. And the Act fails that test, and indeed any level of scrutiny under this court's case law, because the Act and the reasons behind it defy our history and tradition, as well as precedent. American creators have long and always enjoyed the right to speak in conjunction with foreign speakers or work with foreign publishers. Americans even have the right under the Lamont case to receive information from foreign speakers, indeed foreign governments. So that leaves the government with its implication and its use of the phrase national security in this context. But that just simply doesn't change the calculus. Throughout our history, we have faced ideological campaigns by foreign adversaries. Yet under the First Amendment, mere ideas do not constitute a national security threat. Restricting speech because it might sow doubt about our leaders or undermine democracy are kind of things our enemies do. It is not what we do in this country. And so we think the court should reverse, and I would welcome the court's questions.
How exactly is are the creators' speech being impeded?
So two ways, Justice Thomas. First, I just point you to the text of the statute, which directly regulates text, images, real-time communications, videos. My clients, the creators, are the ones creating that speech and posting it to speak to other Americans.
But it doesn't say anything about creators or people who use the site. It's only concerned about the ownership and the concerns that data will be manipulated or there will be other national security problems with someone who's not a citizen of this country or a company that's not here.
So there's two ways, and I think the Sorrell case is where you look for the analysis of the First Amendment burden here. As I said, the text of the statute regulates our speech, and then you point out ownership, and this was talked about a lot in the first part of the argument here, so let me be very clear. The American creators have a right to work with the publisher of their choice. So imagine somebody wanted to work on post speech on Twitter, now known as X, and Congress passed a law saying, we don't like the current owner of X. The current owner of X has to sell that platform or else it has to shut down. People who post on that platform and who indeed some of them make a living commentating, engaging on current events, news, politics, would have a First Amendment claim to work with
using that
publisher.
argument, you could have said that about the breakup of AT&T. You could say that about the foreign limitations on foreign ownership of broadcast companies.
Well, no, I think that you have to dig a little deeper than that, Justice Thomas. It's not mere foreign ownership, and it's certainly the broadcast cases I'll get to in a moment, but it's foreign ownership because of a particular perspective. If you boil it down to an essence, the owner of a print media or online media publication is the essence of the viewpoint of that publication. The current owner of X or the current owner of Fox News or the current owner of MSNBC has a particular perspective, and working with that particular platform is shot through with the ownership from top to bottom.
But why couldn't Congress prohibit Americans from associating with certain foreign organizations that have interests that are hostile to the United States? I mean, I thought that's what Holder versus Humanitarian Law Project allowed. So I don't really understand what you mean.
Right, so I'm glad you're bringing that up.
Yes.
So when it comes to this national security, you are right that Congress can prohibit Americans, to use that case as an example, from associating with terrorist organizations or other organizations that pose a clear and present danger to this country. This case, Justice Jackson, is fundamentally different. What the government tells you in its own brief that it is worried about here are the ideas that might be expressed on TikTok. We might undermine US leadership. We might sow doubts about democracy. We might have pro-China views. And so if you look to whether that is legitimate interest, my fundamental submission, and this I think goes to the last colloquy you were having with Mr. Francisco, is that is an impermissible government interest. And you look throughout our history and tradition, and I think the place I would point you most directly would be the opinions of Justice Brandeis and Whitney and Justice Holmes and Abrams.
I guess I don't understand how that's distinguishable from what's happening in Holder. So can you just say a little bit
It
more?
goes to the nature of the national security threat. So my position is the government just doesn't get to come in and say national security in the case is over, or you don't get to associate. You have to dig underneath what is the national security claim. And what Justice Holmes said in his Abrams dissent, and I know that was a dissent, these are hard issues, but that has been vindicated over time, is that it's not enough to say national security. You have to say, what is the real harm? Is it, is it terrorism? Is it where our battleships are located? Is it war?
Justice Kavanaugh presented a number of potential risks, right? With foreign adversaries using covert manipulation of the data platforms that are being used by youths today that would then make it more likely that people would turn into spies and do terrible things to the United States. This is a hypothetical, but you know what I'm saying?
I get it. So I think if I understood Justice Kavanaugh correctly, he was talking about the data security argument. So let me just pull these apart. You first have an argument, and the government itself separates these two arguments in its brief. The first argument, the one I'm focusing on initially, is the content manipulation argument. And that argument is that our national security is implicated if the content on TikTok is anti-democracy, undermines trust in our leaders. They use various phrases like that in their brief. So my primary submission is that is an impermissible government interest that taints the entire act. Now there's a secondary argument the government makes, and we say you don't even get to that because once you have an impermissible motive like that, the law is unconstitutional. But even if you could get to that, Justice Jackson, I do grant that data security and the way Justice Kavanaugh spelled it out is compelling. That is compelling. You don't have to look any further than the divestiture provision itself, which says that the content recommendation algorithm cannot be used in the future. Well, that has nothing to do with data security. So the core feature of the divestiture provision is going at content manipulation, which I said is impermissible. You can't uphold that under data security grounds. And the rest of the act, when you look at the covered companies provision, Justice Jackson, if this were primarily a data security law, what you think you'd find is what kind of data is procured? How is it stored? Is it shared? Those are the things you think you'd find under covered companies, but you don't find that. What you find is, are text images shared? Is content being shared between users? Is it being created and posted in a social media platform? So I don't dispute for 1 second that data security is a very important thing, and Congress in this very law regulated data security in other ways with data brokers. That's perfectly permissible. But the question before you today was narrower. The question is this law before you sustainable on data security grounds? And that answer has to be no.
Congress doesn't care about what's on TikTok. They don't care about the expression. That's shown by the remedy. They're not saying TikTok has to stop. They're saying the Chinese have to stop controlling TikTok. So it's not a direct burden on the expression at all. Congress is fine with the expression. They're not fine with a foreign adversary, as they've determined it is, gathering all this information about the 170 million people who use TikTok.
Well, again, Mr. Chief Justice, if I may, let me separate where you started, which was the content manipulation, and then go to the data security part of it. So
well, the first part was not, I'm not talking about the content manipulation. I'm talking about the content harvesting.
When you say content harvesting, do you mean people's data?
They've got all the information, whatever whatever algorithms they want, that has access to the personal information, or at least information that is not readily available about 170 million Americans. And whether they're going to use it in 10 or 15 years, when those people grow up and have different jobs in different places, or whether they're going to use it now. That, at least as I look at the congressional record, is what Congress was concerned about.
Well, I think,
and they're not concerned about the fact that it is available. As I said, the remedy is just somebody else has to run TikTok. So they're not concerned about the content. They're concerned about what the foreign adversary is doing.
So if I may, I think to answer your question properly, I think I have to separate two things. One is the content recommendation algorithm. And that's what I was speaking about a moment ago. That has nothing to do with data security. That doesn't itself procure data. That just determines what videos people see on their feed on TikTok. As to that, I think the answer is inescapably that the government and Congress itself was worried about content. The government itself is here saying national security. So like a mix of cat videos or dance videos doesn't affect national security. No matter what happens, the only thing that can affect national security are the substance of those videos. And when the government's pressed in its briefing, it outright tells you that. It says what we're really worried about is sowing doubts about U.S. leaders, et cetera. So let me turn then to data security. Yes, there were various congresspersons, and in the record that we have in the DC circuit, there were conversation about the problem of data security here. As I said, I don't dispute that that is a valid governmental interest. So I think you addressed whether that alone can sustain the act in two steps. First, you would ask, if you have an impermissible motive and a permissible one, can we sustain the act based on the based simply on the permissible motive? And I think for the reasons Mr. Francisco said, and we lay out in our brief, that alone, the answer is no under Hunter against Underwood and other cases. Even if you could get just to the data security question, again, you'd have to ask the question, would this law have been passed by Congress for data security reasons? Because you're being asked to uphold a law based on that single governmental interest. And when you look through the provisions, like the content recommendation algorithm provision, like the covered company provisions, the answer is no. And if you're still in doubt on that, just go back to the under-inclusiveness problem. Would a Congress really worried about these very dramatic risks leave out an e-commerce site like Temu that has 70 million Americans using it, and every bit the connection?
Does Congress have to go all or nothing on that? I mean,
it doesn't have to go all or nothing.
They isolate a particular problem, and they might be getting to what you're talking about next. Who knows? But you're really sitting up there and saying Congress would not pass the divestiture law if data security were the only interest.
So I'm saying it would not have passed this divestiture law if data security were the only interest. It's very curious why you just single out TikTok alone and not other companies with tens of millions of people having their own data taken, in the process of engaging with those websites, and equally, if not more, available to Chinese control. So I'm not trying to say that Congress has to do everything at once. I'm trying to say that once you've concluded that content manipulation, for the reasons I've said, as a matter of our history and tradition, has to be impermissible.
Is there another site like this one that covers half the American population?
I don't think, just by way of sheer numbers, Justice Sotomayor, that the answer has to be no, but 70 million seems like a lot.
170 million is a lot, but put that aside and then go to the next question, which is, how many of these sites have all of the data collection mechanisms that TikTok has? From what I understand from the briefs, not only is it getting your information, it's asking, and most people give it permission to access your contact list, whether that contact list has permitted them to or not. So they can now have data about all of your contacts and anything you say about them. How many other sites gather information by keystrokes to be able to do voice and finger ID information if they choose? And there's a whole lot of data stuff that was discussed in the brief that I don't think any other website gathers. So wouldn't this be a unique site? If I viewed the evidence that way, how would this be under-inclusive?
Justice Sotomayor, I don't think a lot of the suppositions you're making actually bear out. And as Justice Gorsuch was pointing out, one of the, obviously, the real challenges in this case is it comes to you without an ordinary trial record compiled and all the rest. So we have only limited amounts of information, but absolutely these other websites are taking much the same kind of information, if not more. And as to the contact list thing, I think that points out one other aspect of this. That is voluntary decision by an American user to share that information. In the Riley case.
But not informed. And
Well,
even if informed.
that could be solved. If you don't think it's informed, that could be solved by
no,
a
that
warning or
can't be,
disclosure.
because for the United States, the threat of using that information is what is at issue. It's not whether the user thinks it's okay. It's whether the U.S. believes that it could put sites at issue. But let me ask you one last question and fundamental question. Assuming that content neutral data collection concerns were is one of Congress's provisions, divest because of this. Why can't we separate that out from how we analyze the algorithm question? And couldn't we sever the two provisions to say divestiture is right, but you can't force them not to discuss algorithm.
Well, I think the reason why you can't do that was Mr. Francisco explained. I thought I'd direct you to a case like Hunter against Underwood and just analogize it to this situation. If what you had is the government saying, we are shutting down TikTok or requiring divestiture for two reasons. One, because we think it helps the Democratic Party too much. And number two, because we're concerned about data. I think that first interest would be a poison pill. That would be an impermissible, or because we think there's too much pro-Catholic content on TikTok. I think there are some interests that are just so constitutionally verboten that I think that just makes the act unconstitutional, and you can't go looking for other interests. You send it back to Congress. Look, if you want to pass a data security law free and clear of this impermissible interest, you go ahead and do it.
So,
Can I say one other thing, Justice Sotomayor, just because I think it is also telling here that even if you didn't buy that poison pill argument and you just asked whether Congress would have passed this law, something else that I think you might notice is even if all this act goes into effect and the law goes through, TikTok gets to keep all the data.